Hey out there, legal warriors. Can your ex-partner, your husband, your boyfriend, your wife, your girlfriend, somebody who's a victim in a domestic violence case with you as the suspect, can they drop charges against you? Is it up to them? If you're interested in the answer to that question, stay tuned because this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm is defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. I'm not just going to jump right into it. This is a very frustrating topic and one of the most common questions we get in my office. Hey, can the victim of a crime, especially a domestic violence crime, can they make the charge go away? Can they drop charges? And the literal answer is no. They're not allowed to drop charges. Now, stay tuned. This doesn't mean it's hopeless. There are things they can do, but the legal answer to the question is no, they cannot drop charges because they're not the ones that are the plaintiff in the situation. In criminal law in Washington state, the victims or alleged victims of crimes are not the plaintiff. The government is the plaintiff. There's a plaintiff, the prosecuting authority, the government, and the defendant, who is the suspect, the person accused of a crime, or in some cases arrested for a crime. And they're the ones pressing the charges, if charges are to be pressed, and they're the only ones, the government, that can drop the charge. So who is the government person that decides to drop a charge or not? It's not the judge. It's the prosecutor. The prosecutor is an attorney that has been hired, in most cases, to provide prosecuting services for the government. Some counties elect a main prosecutor who then has a budget to hire deputy prosecutors. And in some type of cities and things, there are law firms that bid on contracts to provide prosecution services. In some cities, they have their own internal lawyers that provide prosecution services. So the victim is not the plaintiff, cannot drop the case. Only the prosecutor can. So does that mean that if you're an alleged victim and you don't want the case to go forward, is that helpless? Are you in a helpless situation? Is it hopeless? No, while you don't have absolute power, you hopefully can have some human influence to have a prosecutor at least listen to some degree what your wishes are. So there's a couple different situations. The one situation is where the defendant is actually charged and already going through court, officially charged with the crime. And a different type of situation is the suspect has been arrested, but they're not formally charged yet. And I cover those different situations in other videos. But basically, in a felony case, a police officer can only arrest someone. They can't charge them, and so that takes a longer time typically to charge, days to months to even a year sometimes. And on misdemeanor charges, if it happens in the city limits, typically a city police officer can file the charge right away, but a county police officer typically has to send it to the prosecutor's office, the county prosecutor's office, to decide what to do, and the reasons for that are covered in another video. But so these are different situations. On a charged case, certainly the victim has very little ability to force the prosecutor to dismiss the charge. They can't, but they can tell the prosecutor what their wishes are. I don't want my partner, my brother, my sister, my wife, my boyfriend, my girlfriend convicted because it'll ruin their life or it'll hurt their job prospects or they didn't really do it, whatever the reason is. Then the prosecutor will at least listen to that, but they're sort of tone deaf to victims saying they want cases to go away because in their mind, and there could be some truth to this, people that are abused will change their story later to protect the person that's abused them for all types of complicated reasons, which I'm not going to get into here because there's different ideas about that. And so a prosecutor is a little bit tone deaf to that, but each prosecutor's different. Some people will really listen to that as a prosecutor as a good way to resolve a case in a way that's more favorable for a defendant. Some will just close their ears and proceed right forward. And hopefully if there's a defense attorney representing the defendant, they'll know a little bit about what that particular prosecutor is like because criminal law is very local. There can be a totally different result within the same prosecuting attorney's office based upon one prosecutor thinking about it, and a different prosecutor gets the case and think about it differently, let alone different jurisdictions. So you have less power there to drop a charge. You have no power to drop it, but you do have power to keep on the prosecutor about what your wishes are, because again, you're the supposed victim. Your wishes should matter. That's what I think. The other situation I covered is when a case is not charged yet. And while you still have no power as a victim to drop a case there, the victim has no official power, they have a little bit more influence based upon human nature. Let's say the case is 3 months or 6 months since it happened, or 12 months since it happened. A prosecutor, if they have some wisdom, in my opinion, I prosecuted for 7 years myself, it might be wise for them to get a hold of the alleged victim and say, hey, what are your wishes now? How are things been for the last 6 months or a year? Probably still living together, you're probably still married, or brother, sister, you're still related. And have there been other problems? Do you want me to reopen this can of worms or not as the prosecutor? And in that case, there's plenty of jurisdictions that are more willing to listen to the alleged victim about their wishes. Now, it depends on the record of the defendant. If the defendant's got a bad record, well, they're going to put the victim in that category. I'm not going to listen to you because you're protecting the bad person, right? But if they've got a pretty clean record and you're pretty certain about what you want and they're not serious injuries, and we've got a sort of an experienced and seasoned prosecutor, they might decline the charge, not because you had the power to do so as the alleged victim, but because it makes sense to them based upon their experience and what's to be gained by prosecuting against the victim's wishes versus how difficult it might be to achieve anything in that situation. Actually could make the overall life situation worse. So while we don't have the power as an alleged victim to drop a charge, we do have influence if we sort of know what to say and hopefully know what not to say. The more, in my opinion, the more an alleged victim uses words like I love, I want, I need, I think that more, the suspect, I think the more that triggers protective behavior from authorities, the more an alleged victim sounds like, I wasn't injured, there's been no more problems, I do not need this help, though I appreciate that you're there. Here's how things have changed since then, and if there's another problem, I absolutely will stick up for myself, call the police, etc. That will trigger less protective feelings typically in law enforcement or a prosecutor than the other type of language, in my opinion. Now, if a defense attorney is helping the defendant, they're not allowed to give legal advice to a victim. It's okay to talk to people on the side because you're a witness. You might need your own legal counsel, and there's plenty of attorneys out there that will represent alleged victims to try to help them get either a certain result in favorable of the defendant or against the defendant. We do that type of work as well. But in many cases, there's going to be some type of victim's advocate that communicates with you as the victim. And then you're able to say your wishes to that person, to him or to her. And don't rest too easy, because some advocates, like all things are different. Some will be more, just tell me what you want, and some will, feel it's in their interest to try to influence you one way or another based upon, what's going on in their head and how they see the world and how they see their role in the legal system. And just like prosecutors, that varies as well. So it's not hopeless, but please, if you're a suspect, a defendant, just a member of the public, realize that victims do not have the power to make charges go away, and they don't really have the power to make charges happen. That's up to the government, and there's a good reason for that, because the government is the one that is charged with proceeding with the case and deciding from their point of view what the right thing to do is, and then the defense gets the right to challenge that. So, if you found this video useful, please like and please subscribe. More people get the help they need. And more importantly, if you have a legal problem, if you have a criminal case and you need some help in Washington State, please feel free to give my office a call. We've been doing this more than 20 years. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.